Hello, everyone. This is Ifeoma Odunlami. I'm waiting to get on. Hang on. I'm trying to get on Instagram as well and YouTube. Hi, everyone. Good morning. Happy Monday. Um, Again, my name is Ifeoma Odunlami, immigration attorney from the Odunlami Law Firm in New Jersey. We serve clients in all 50 states. Our passion and our mission is to help our fellow immigrants, I'm an immigrant as well, to gain legal status without fear of deportation. So, today I have a really important topic, and I thought about this because last week my second daughter turned 17. I took her to the DMV to do her driver's test, and she did her driver's test and she passed, and she was really excited. Now she has a driver's license, provisional driver's license. She can drive. But I was thinking about other kids who are here, and because they don't have status, they're not able to do simple things such as getting a driver's license, getting tuition so that they can go to college, getting a job. These are things that, as I think of my American children who are born here, they don't have to worry about it. They can go to DMV, get their driver's license. They can apply for college. If get a loan if they wish to, or get in-state tuition, or they can get a job. And if you think about it, right, young people, right, are not able to do these things if they don't have legal status. And it's difficult enough for us, for older people who are undocumented. But can you imagine a young person who's being told that you can't even move forward with the plans you have for your life? Imagine that. They want to go to college, but they can't. They want to get a driver's license. All their friends are getting a driver's license. All their friends are driving, but they can't. You know, and when you think about it, it's just so unfair. So there are many situations and many federal immigration laws that make it possible for children to get some kind of, you know, work authorization, such as DACA, which is not in existence right now for new applications. But I want to talk about something that's even better than that. I want to talk about Special Immigrant Juvenile Status. Special Immigrant Juvenile Status is a pathway to a green card, right? It's not a pathway to getting a work permit. This is a pathway to a green card. That child will get a green card at the conclusion of the case. That child will be able to move forward with their life. Within 5 years of getting their green card, they can naturalize, right? So this is why it's so important to me that I want to make sure that children who qualify for this know about this, because there's some children who do not qualify, right? Or who do not know that they qualify. And by the time they realize that they qualify, it's too late. So I want you guys to share this video to as many people as you know, because you just never know the young life you're going to touch. So let's talk about Special Immigrant Juvenile Status right now, okay? Special Immigrant Juvenile Status is pretty much a federal law, right, immigration law, that says that if a child has been abused, abandoned, or neglected by at least one parent, it doesn't have to be two parents, at least one parent, right, and that child is single, which is unmarried, right, and that child is under the age of 18 in some states, 19 in other states, 21 in other states. In New Jersey, it's 21. New Jersey and New York, the child has to be under the age of 21. So the federal immigration law says that if this child has been abused, abandoned, or neglected, right? And note that the abuse, the abandonment, or the neglect does not have to happen here in the United States. However, the child has to be here in the United States. So the abuse might have happened in the home country, right? Or the abandonment may be that the child is here and the parents, one parent or both parents, are not taking care of the child, not providing for the child. Or the neglect is like they're not doing things they're supposed to do for the child. So if that is the case, that child could qualify for Special Immigrant Juvenile Status. So the first step is to go to court, family court. So each state has a different definition of what abuse, abandonment, or neglect is, right? For instance, in New Jersey, the death of a parent is abandonment. So if you have a child who has one parent who passed away, right, that could qualify the child for special immigrant juvenile status if all the other factors are met, because we can show that one parent has abandoned the child through death, right? And it doesn't matter if the other parent is alive. That if that child is here, is single, under the requisite age in New Jersey is 21, right? And can show that it's better for that child to stay in the United States than to go back to their country. And you can show that you cannot reunification with that parent is not possible, which is not possible if the child, if there's a death, right? That child could qualify for special immigrant juvenile status. So the first step is in family court, right? And in family court, you prove the case of abuse, abandonment, or neglect. It doesn't have to be all three of them. It could be one or the other, right? So I'm going to talk a little bit about what abuse is, right? Abuse, we all know, if your parent is being physically abusive, beating the child. And like I said, it doesn't have to have happened here in the United States, because most of the time, typically, that parent is in their home country, right? So the abuse could have happened in the home country where the child was being beaten or emotionally abused. Maybe the parent wasn't, was not providing food for them, or was treating them badly, right? Or abandonment. You have this typically happens in many scenarios where there's an absentee father or mother. Maybe the parent has never been in the child's life, right? It could be that, or it could be that they left the child here in the United States with a family friend and basically stopped taking care of the child, forcing that family friend to be in charge of the child's well-being, right? Or it could happen in a situation where there's actually been some behavior that got the child welfare involved. I had a case a long time ago where a child had been abused by a step parent, and child welfare got involved, and were able to get a family SIJS petition going, and the child was ultimately able to get their green card. But it doesn't have to be the right level of child welfare getting involved, right? Like I said, it could be plain abuse. The parent is, physically abusive, emotionally abusive, psychologically abusive, doesn't help the child, is not there for the child emotionally, is not there for the child financially, doesn't take care of their child. This could all be ways that you can show that the child has been abused, or has been abused, neglected, or abandoned. So once you make that, you present that, right, and you can show that it's best for the child to stay here in the United States and not to be reunited with that abusive parent, then you present the case in court. Now remember, even a non-abusive parent can also bring the case to court, requesting that the court give an order making the special findings that the child has been abused, abandoned, or neglected, right? So in family court, there typically is somebody seeking custody, somebody over the age of 21 who's seeking custody of the child who's under the age of 21, right? And I say 21 because that's the state in New York or New Jersey. So in your state, you have to figure out what the state, the age is. So in that case, that person can come. It could be a friend, it could be the other non-abusive parent, it could be another family member. They can come to court and request that the court make these findings. At the end of the court hearing, we're supposed to get a predicate order. That predicate order will enumerate the findings that we've discussed to show that this child qualifies based on those findings. Now, with a predicate order, right, we go to immigration, we go to USCIS and file the I-360, right? Now, sometimes we'll file the I-360 and the adjustment of status at the same time, but for certain countries, right, they can only file the I-360 first and wait for their priority date to be reached before they file the adjustment of status, right? It depends on the country. And then you put in the paperwork, and typically in all my cases, we haven't had any interviews. We just get the green card in the mail, right? And for most people, it's taking about a year. For those people who have a current priority date, it's taking a year from when you file the SIJS case to when you get the green card. Okay. So now the important thing I want to say is this, right? Please don't wait until you're almost 21 to start the process, because family court is backlogged and there's no guarantee that they can get your case before the court before you're 21. So I typically tell people to, at least 6 months before, try to get the process started. All right. And another thing, the good thing about SIJS is that SIJS does not care how you came into the country. You could have come in with a visa that's now expired. You could have come in with a student visa and you're not in school anymore. You could have come through the border. It doesn't matter. You're eligible to adjust your status regardless of how you came into this country. So you have to understand that for a young person, this is a really important way to get their green card. So if you know anybody who might qualify, have them call my office, 973-993-1900. We do a lot of SIJS cases, and it's our honor and our passion to make sure that young people have the best chance they can get to start their lives. Okay, so let me look at the comments. Damilola says, you haven't responded to my mail yet. Damilola, can you send the mail again? Because I don't recall getting any mail from you or email. Or better still, call my office, 973-993-1900, and schedule an appointment so I can talk to you. So the other, Stephen Miller says, good morning, how are you? Almost after 1 year, I finally hear from USCIS. Now, after all this time, they're now asking for my sponsor, who is my wife's tax document. Well, Stephen, at least they're asking for this. That means that your case is going in the right direction. Unfortunately, USCIS is so backlogged. It's so frustrating. I hear your frustration and I feel it, but once they start asking for your tax documents, it means that your case is being, worked on and it's moving in the right direction. So go ahead and send your wife's tax documents. Make sure that her income is enough to support the application. If it's not enough to support the application, you will need to get a joint sponsor whose income should be enough to support the application as well. Okay. So if you have any questions or you need help with that, give my office a call, 973-993-1900. So you guys, I just wanted to stop in real quick to talk about Special Immigrant Juvenile Status. And another positive about Special Immigrant Juvenile Status, even if the child is in deportation hearing, right, in deportation court, and you can still file Special Immigrant Juvenile Status and get your green card and get out of immigration court that way. So I hope this has been helpful to all of you, and I will log off right now, but I hope to be back this week. I want to talk about abuse in relationships. Okay, VAWA, Violence Against Women's Act, Violence Against Women's Act, Violence Against Women, Violence Against Men, Violence Against Children, Violence Against Parents. Okay. All right, Mr. Task, watching from Houston. Thank you for coming in. I'm just about to sign out, but do you have any questions I can answer before I sign off? All right. Okay, today's Monday and I'm hitting the ground running. Last week was a really great week. I mean, the past couple of weeks, we've gotten so many green cards coming in from really difficult cases. And oh my God, it's been so joyous to tell my clients that the struggle for them is over. The struggle could be over for you as well. Call my office. Let's see how we can help you. All right, guys, take care and thank you for tuning in. Bye.